Greetings everyone and welcome to Elephant TV. My name is Gautam Bhatia. Today I'll be speaking to Gautam Bhatia. Mr. Bhatia is an Indian constitutional lawyer, currently finishing his PhD at Oxford University at the UK. Welcome, Mr. Bhatia, to the Elephant.
Thank you.
Great. Just to kick off this conversation off, you recently penned a three-part analysis on the recent ruling by the Court of Appeal, the Kenya's Court of Appeal around the BBI judgment, which was passed by the High Court 3 months earlier. And I mean, there's a lot to be said in this 1,809 pages document, but your analysis focuses on three parts: public participation, what you called the fourth arm, which you call IBC, and the place for the basic doctrine. Just for audience, why do you think these three parts were very important? One for legal scholarship, but two, which I think in my view is a more important one for Kenyans, because this is a living document for their livelihoods and for their existence. Why do you think these three parts that you focus on are very important?
Yeah, so I think I'll answer the second part of your question first, which is the importance of these three sets of issues in very practical terms.
Right.
Now, I think one thing that a constitution does is that it creates a scheme for the distribution and allocation of power.
Right.
And classical constitutional theory always envisages three branches: judiciary, legislature, executive. And the kind of political system a constitution sets up allocates power between these three branches.
Right.
And when you have, and any constitutional text has silences, gaps, and ambiguities. And so whenever you have a case like the BBI case, a lot of the arguments involve interpreting those gaps and silences in a way that will alter or redefine the balance of power that constitution creates. And I think that with respect to the basic structure doctrine, public participation under Article 257 and the IEBC, these three issues really at the core of an effort to democratize power relations under the Kenyan constitution, and to ensure that there is no concentration of power in the office of the presidency, and by extension also in political offices. So for example, and I think the clearest example of this is in the court's analysis of Article 257, which is amendment by popular initiative, where the court, in fact, by a 7-0 majority, holds that this provision, when read in its historical context, was meant to provide an avenue for the Kenyan people to bring to public attention issues in the constitution that might require rethinking and amendment. And that purpose would be defeated if this process was to be driven by politicians, the president, or other parliamentarians. And so the court really carefully scrutinized the entire chronology going back to the handshake and said that this is very clearly an executive-driven process. Now, the provision itself is silent on that. The provision itself doesn't the executive drive the process, but the court interpreted that silence in a way so as to say that actually a provision meant to empower the people or give power to people cannot be then used to empower the presidency. So I think that's why, and the same things apply to the basic structure doctrine and also to the IEBC. So I think that's why these three are particularly important.
Okay. I mean, just to piggyback on your answer, in your third part analysis, you talk about the idea, introduce the idea of the fourth branch, which is called the IBC. And which can you elaborate what actually this fourth branch is and why it's very important for a democratic country like Kenya? Because you introduced this idea that for many, we talk about three branches of government: executive, legislature, and the judiciary. But you talk about the fourth branch. You even talk about the information commissions, IBC. Why is then, in our case, IBC a very important commission and institution for Kenya's democracy?
Yeah, so again, I mean, if you look at classical constitutional theory, you have three branches: executive, legislature, judiciary. and both the executive and the legislature, in some sense, draw their power from from elections. And the judiciary is the counter-majoritarian branch that checks those two when when they transgress their limitations. But over the last few years and even decades, there's been this understanding that this is insufficient to guarantee the thriving of a constitutional democracy. So you also need fourth branch institutions that are also not elected and are independent from the elected branches. The reason for this is twofold. One is that many rights that a constitution guarantees are not self-executing rights, and that you need an institutional structure to make sure that those rights are actually effective and make sense to people's lives. The classic example is an election commission, because to have an election, you need to have an independent body that monitors the election, that declares the dates of the election, is responsible for constituency delimitation, and so on. It's the same thing goes with the Information Commission. It goes with for ombuds people, for watchdogs. South Africa has a public protector, and so on. So what these fourth branches do is that they function independent of the popularly elected offices, presidency, parliament, and so on, and act as a check on the day-to-day functioning, and also to make those rights like the right to vote, the right to information effective on a day-to-day administrative basis. In a way that courts can't, because courts can't oversee the implementation and the finer details on a day-to-day basis. The courts can adjudicate on disputes, and sometimes, of course, they can oversee implementation of their judgments, but they can't effectuate the right to information, the right to vote. Data protection is also a big contemporary issue on that front. That's why bodies like the IABC are important. And in fact, if you look at Article 88 of the Kenyan Constitution, the IEBC's role is really wide-ranging. It's to monitor referenda, elections, constituency delimitation, demarcation, and so on. And without these functions, you obviously can't have free and fair elections, which of course is a big issue in Kenyan history, is my understanding. And more than that, it's even more important in the IEBC case, because democratic legitimacy flows from elections. And so the referee who has to monitor that process is particularly crucial and needs to be independent, because if that is compromised, then everything else downstream is also compromised. That's what makes the IEBC a particularly important institution. And that's why the court's rulings on quorum, on there needing to be a legal framework for the IEBC are so important.
Right. I mean, and you mentioned in your analysis that yes, both the rulings have done a lot of pioneering work, in terms of really interpreting the constitution, and it'll go a long way. But for a country like Kenya and parts of the developing South, right, where our political elites are known to over and over time to try and change the constitution for their own benefit. Well, what are some of the missing points or areas that you feel that Kenyans need to also start interrogating, having conversations around, and the courts being to even interpret them deeper, so that we can really strengthen our constitution and really infuse constitutionalism towards our democratic spaces?
So I wouldn't say there's something missing. I'd say that there's some points that because the court wasn't dealing with them, it didn't yet rule on them.
Okay.
But future cases might have to deal with them. So I think one example I think is a very Kenyan specific one is Article 257, public participation. Because so what happened in this case, as you know, was that this was the executive driven. The BBI was executive driven, and so the court kind of strikes it down, and the court says that a process under Article 257 needs to be public driven and have public participation. But then the question, as was raised in the hearing, and as some of the judges also acknowledged, is that you can't really impose the burden of ensuring public participation upon an ordinary person. That's an obligation on the state. Now, if an ordinary person or a group of people want to initiate an amendment process, they don't have the resources to, have this wide-ranging, public participation that is required, under Article 10 and so on. And so the court is aware of that, and it sounds a few notes of caution. But of course, because that wasn't the issue before, it doesn't go deep into it. But future cases then might actually have to deal with that. So to balance the requirement of public participation on the one hand with the fact that 257 seeks to empower ordinary people to initiate an amendment process will be an interesting future question. I think leading on from that, I think something that will be very important is that whenever you have an appeal to the people, whether it is by political elites or by courts, the risk is always there that within the people, then you will have certain dominant voices who will exclude, other voices. And so in this case, there is this very strong focus on public participation, and it draws from previous Kenyan cases that, in fact, we in India have often used to try and make the same case in India. So, we often use Kenyan cases for public participation. But then, of course, and it's a good thing. But then the future, I think in future, there would have to be a little more thought given to how you can ensure that in a public participation driven process, it's genuinely pluralistic and inclusive, and doesn't mean that the loudest voices ultimately still drive it. They're not politicians, but they're still like louder voices, right? So I think that's something worth thinking about. If indeed, and it seems to be the case, public participation is going to be a foundational value in these provisions going forward.
And touching on public participation as well has been the High Court ruling and also the Court of Appeal ruling, and also public debate around Kenya. There's been this issue of basic doctrine. And even during the Court of Appeal, there were people saying that basic doctrine doesn't exist in Kenyan law. We can't borrow outside of the public, and in many cases the political debate. Why is the idea of basic doctrine important to constitutions?
Yeah, I think there are two or three reasons. One is, and this is something that's happened across the world,
right.
Is that when politicians don't like the constraints that a constitution imposes on them, they do a number of things to get around that. One of the things that they do is amend the constitution.
Right.
This was a big issue. In fact, in India, the reason why the basic structure doctrine was adopted by the courts in 1973 was that in 20 years after Indian independence, every single time there was an adverse court ruling, the Congress party, which was then enjoying a comfortable majority in the Indian Parliament, would just amend the constitution and remove the basis of the court ruling. And finally, the court said, "Look, enough is enough. We are putting a stop to this." So what politicians do is, when the amendment process is relatively easy, is that they just they undermine the rule of law by just getting around inconvenient judgments by changing the constitution. That's one thing. The second is that, and this is something I draw from the arguments made by many of the respondents' counsel in the Court of Appeal,
right.
Is that you can destroy a constitution in two ways. One, of course, is in a coup, in a revolution. You just kind of sweep away the old order and there's a new one. That's one way of doing it. But the other way is a more subtle way, which is an implied repeal, which means that you add to a constitution features that are so fundamentally incompatible with its existing identity that
right.
effectively it's no longer the same constitution. So you have the extreme example, which is an example given by the judges in the Court of Appeal in their oral arguments, is that tomorrow you just change the constitution to make Kenya a theocracy or a one-party state, like going back to the past.
Right.
Then it's no longer the same constitution; it's something else. And so I think it's important to have a kind of protection against that kind of implied repeal that comes from top down. And I think one really valuable contribution that the Kenyan courts have made to global jurisprudence on this is that until now, the basic structure doctrine basically was that if you are altering the basic structure of the constitution, changing it to some other constitution, then it's a complete bar. You can't do it. Like it's just out of question. I think the Kenyan courts have done something very interesting, and to me it makes logical sense. What they've said is, yes, you can do it, but if you want to actually alter the constitution's identity completely and make it into effectively a new constitution, then you have to replicate the conditions under which the constitution was created. Because what you're doing is effectively an act of refounding
Right.
and not amending. So you can do it, but then you have to go through the entire 4-step process that was involved in the framing of the 2010 constitution. That's public participation, civic education, constituent assembly debate, and a referendum. So you can still, so if the people want, then the people can still refound the constitution. But the political elite cannot do it simply by, by having a big majority and just ramrodding through massive amendments in that way. So I think that that's a very important contribution that the Kenyan courts have made to global understanding of why the basic structure is important and what its elements are.
Okay, right. I mean, in many cases, Gautam, India and Kenya, I mean, we share our similar colonial past, and a lot of jurisprudence is actually very the same. And to move the conversation to a bit to a political question is that, in your view, what have these rulings done to Kenya's judiciary, coming from a history where the judiciaries of colonial systems were meant to be kangaroo courts? They were meant to really serve the interest of the British minority, and then post independence, serve the interest of the Black minority political class. What does this ruling mean as regards statehood and constitutionalism for Kenya's democracy?
Yeah, no, I think first of all, I appreciate the shared past that we have. I think I just recently saw a great Twitter thread on samosa in Kenya.
Yes.
It was a wonderful tweet. But to answer the question, I think it's really, and again, so my understanding, of course, is an outsider, so it's going to be, of course, limited, and there's many contextual nuances I'm sure I'll miss. But I think what's really important is that what you had here was two really politically powerful players who were at opposite sides in the previous disputed election that was set aside by the courts, and they both have a long political history in Kenya, right? And they had both gotten together to try and push through the BBI, and so you basically had. So it wasn't simply a case where, say, an evenly balanced political spectrum, you have, a politically contentious move,
right,
where the court's kind of adjudicating like a finely poised political dispute. Here it was two very influential figures coming together with their followings and uniting to push this through, which basically effectively meant a large segment of the political establishment, was behind this. And in that context, for the court to say that, two courts to say one after the other that no, you cannot do this, and in fact to say it by significant majorities, I think it establishes judicial independence in a really important way, because what we often see in constitutional courts, especially in post colonies, is that what courts will do is that they will play this kind of negotiation game with the government, where if there's something that's really fundamental that the government wants, it's integral to its agenda, the courts will greenlight that, and that will give them the breathing space to maybe pass some progressive judgments on social rights. So it'll be like this constant negotiation, push and pull, where the government is allowed to have its core agenda pushed through, and in other marginal spaces the courts kind of intervene. And I think that what's really important here is that this was something that was really, really clearly important to both His Excellency President Kenyatta and the Honorable Raila Odinga, and the court stopped it. So I think that of course the counter argument is that the court was posturing, excessive activism and so on. But if you kind of bracket that internal dispute, I think for the rule of law, it's important that a project that had such firm political backing was set aside by the court, because that really sends a very powerful message that the courts are in a position that if they genuinely think something is unconstitutional, then they will not engage in this kind of negotiation, but will actually say that it is unconstitutional and therefore has to be stopped. So I think that sends a very important message, a very important public-facing message two judiciaries, I think around the world and of course within Kenya as well.
Okay. Well, last question, Gautam, before I let you go. I mean, as we all know, of course, the political class won't take this defeat on their part lying around, and a similar situation happened in 2010 when we passed the constitution, whereby Kenyans passed the constitution, and for the majority thought, now this is over, we passed the constitution, we fought for 30 years,
Yeah.
now we can go doing its own business. But in the last 11 years, we have seen, particularly the current regime, the Jubilee regime, we have seen blatant executive orders going against the constitution. We have seen the commissions, independent commission, are not subscribing to the decrees of the constitution. So then, what do we? I mean, as a constitutional lawyer, what do we need to start doing as Kenyans to make sure that even the gains we've made with now the recent Court of Appeal ruling, that not only do we cement them, but we also move forward? What are some of the things to start building the critical thinking to realize that constitution is progressive, but we also rail it against, in a sense, a political class who will, of course, down the road try to change it or try to do something again? What do we need to start doing as a country?
So I think that I was really struck when I watched the Court of Appeal hearings at the sophistication and at the nuance and the sheer quality of arguments that the lawyers really brought to the table.
Right.
And I was really struck by how many of them were young lawyers who were arguing for half an hour, 1 hour. And that rarely happens in India. And I thought that as long as this group of lawyers is around, at least as far as the court is concerned, you really have nothing to worry about, because you have, I think, an excellent set of counsel who will take these cases to court, and you also have an excellent set of scholars. I've really been following the work for a long time, and they've taught me a lot. Like Walter Osheng is someone whose work I read, and other scholars. So I think all the ingredients are very much there, and I've seen that you have groups like the Katiba Institute and so on,
Right.
who take this to the people and to social movements. So I think it's all there. I just think that ultimately what can succeed is a coalition of social movements, lawyers and scholars working together, sharing information, collaborating and ensuring that these kinds of cases come to court at the right time with the right strategy and with the stakeholders all being involved. And from what I've seen so far, it's all happening. So I think like I'm really like I just love to see like all this happening. I think it's great. So I think that if that continues on its trajectory, there will be like a strong set of institutions and people who will be in a position to defend the Kenyan constitution and the gains made. Of course, it will be hard, but it's all there. Like, it's all there to do it.
Okay, thanks, Mr. Gautam, for your brief, for sharing your insights here at the Elephant, and also for your numerous articles you've penned for us on these legal matters. So thank you so much for your time.
And thank you. It's been a great privilege to have followed this case from the High Court up, and it's been wonderful to follow it and to engage with it.
Thank you so much. And for our viewers who are watching this, please be sure to subscribe to our YouTube channel, follow us on Twitter and on Facebook, and also subscribe to our newsletter and check out our content at theelephant.info. Thank you so much. Asanteni.